Welcome back to the show, everybody. Check out these headlines. We got a powerful video lined up for you today. Ripple policy chief co-signs new pro-crypto U.S. legal act. You're going to want to know about it. SDNY judge stops the SEC. John Deaton on Fox, and then a special message from John Deaton about the entire crypto space, saying this will be a long fight. Somebody roll that beautiful intro.
Digital Perspectives with Brad Kimes. Come on in.
Welcome back to the show, everybody. You can follow us on TikTok, YouTube, and Twitter for exclusive content. Right now, cryptocurrency market cap is $1.06 trillion. It's off by 1%. Good morning, everybody. Bitcoin, 22,000, slightly over. Ethereum, 1559 and change. Tether market cap, 71.7 billion plus. We watch it closely. XRP, 38 cents this morning. It's up 3.9% on the 24-hour. Let's get started. And I tell you, if you are into private equity, investing in the companies behind the technology, know this. Link 2 is the place to go to have that opportunity. We secured a limited block of Ripple inventory, and it will be available on link2.com today, this morning, March 8th, ladies and gentlemen, at 8 a.m. Pacific time, just a couple hours right away from now. With the Judge Torres having ruled on the Dalbert motions, a settlement is expected soon, and sources for Ripple equity are drying up. Your opportunity to get a hold of this, the window is closing, ladies and gentlemen. Do not mess around. Click that link underneath the video. Check out my sponsor there. And shout out to John Deaton, as he made that prediction 2 days ago and said, I seriously doubt that we would see a significant delay from here. This was after the ruling on the Dalbert motion came out in the SEC versus Ripple, and went on to say that it could be tonight or in a couple weeks that we get the summary judgment ruling. So again, the window is closing, ladies and gentlemen, and keep an eye on this, because this right here from Eleanor Terrett, the primary focus on the Keep Innovation in America Act, co-led by House Financial Services Committee Chair Patrick McHenry and Richie Torres, is narrowing the definition of crypto broker for tax purposes. Now, we know that in the infrastructure bill, there was too broad a definition of broker underneath of crypto and the definition for that. So hopefully this will bring clarity, and this should really bring a little clarity that the bill is in the right direction, because Ripple's policy chief co-signs the new pro-crypto U.S. legal act. The head of public policy at Ripple, Susan Friedman, has expressed her support for the Keep Innovation in America Act, a bill designed to fix the crypto market's current regulatory faults. This is also about bringing back in line the different agencies, as we know, that are going too far. It says here, if I could find the section here I wanted to read to you. I had it highlighted, and now it's gone. But you know what? It's not that far. Let me just read it. So it says here, the head of policy has signed that, and as stated by the source, the definition of crypto broker, or rather narrowing its application for tax purposes, will be the center of the Act's agenda. In addition, the drafters of the Act plan to limit the federal government's ability to define what constitutes a digital asset. As Friedman notes, the Act would make sure the term is not defined in a way that creates unfeasible reporting requirements for the industry as it does now. The title of the act speaks for itself. According to one creator, Patrick McHenry, current misleading policies and regulatory overreach are pushing a dynamic industry with all its perks abroad out of the U.S. The current permissiveness of regulators toward the crypto industry was made possible in part by the Infrastructure Investment and Jobs Act, which we just talked about and referenced. If it gave regulators broad powers to determine the rules of crypto market, the new act should limit it. That's what we need to see, and put Gary Gensler and the SEC back in their lane. Now, this is another piece of information that's coming up. There's another hearing that's coming up tomorrow, and this is the final list of witnesses for the Digital Asset Subcommittee hearing, the first one ever. If you remember, they put this subcommittee together to try to get more clarity on how they need to craft legislation for cryptocurrency space. This here is Lee Reiners. If you remember, boy, we covered Lee, and he is not a fan of crypto. That's putting it lightly. Well, he's just been added as the additional witness to Thursday's hearing. We're going to tune into that one for you as well. Judge in the Southern District of New York says he will stop the SEC from interfering with a bankruptcy case. Boy, can I read that a second time? Because it just felt good to hear that, didn't it? A judge in the Southern District of New York says he will stop the SEC from interfering with a bankruptcy case claiming a new crypto asset is a security. Well, let me tell you, this is a fine piece of reading right here. The SEC issued an objection to bankruptcy proceedings for the embattled crypto lender Voyager earlier this year, which would help repay customers affected by the lender's collapse. Judge Michael Wiles initially said he needs specifics on why the SEC objects and why it has decided to stop everybody in their tracks, with little to no explanation of its concerns. Now, in a new ruling, Judge Wiles says that the SEC stance would do nothing but damage, leaving a sword hanging over the heads of anybody who's going to do this transaction. The judge blasted the SEC's interference, asking, how can a bankruptcy case or any court proceeding function with that kind of suggestion? The bankruptcy proceedings stem from Binance US acquisition of more than $1 billion worth of assets from Voyager, a deal that was signed after FTX's plans to acquire the assets vaporized. Judge Wiles says that in the future, the SEC can pursue Binance US or Voyager's attempts to actually issue a bankruptcy token. But he says it would be plainly wrong to punish individuals for working on their proposals in court. Finally, we're seeing some pushback. And this right here is 1 year ago, back in July of 2022, and I'm not going to play it, when John Deaton appeared on Fox Business with Charles Gasparino, when the SEC tried to throw John Deaton out of the case as a friend to the court. Well, they failed. And they tried again, and they failed again. But now he's here again. And here we are in March of 23, and I want you to listen to this. And then we have a very special message from John Deaton after this clip that you need to hear.
District judge may be close to announcing a decision, the outcome of which will impact the entire crypto industry. Joining me now is lawyer John Deaton, who's closely involved in the case, and our own Charlie Gasparino. And you two have had many conversations on there. I've been
battles.
Yes, about this.
You're still with us. I mean, in terms of the case.
Yes, I did.
Explain. You're on the side of the Ripple shareholders, right? You're advising Ripple.
No, I'm for the XRP holders.
I'm sorry. Yes,
the individual retail holders. We have 75,000 plus.
I'm going to get a lot of crap for
that. That's okay. But amicus curiae, the judge. I filed a motion to intervene. The judge said, "Well, I'm not going to let you become a defendant with those 70,000 people, but you can be amicus curiae, you can participate."
And the SEC trying to get you kicked off.
They fought us at the beginning, and then they filed motions, and they tried to kick me off, and
you're still here.
Lost. And we got a good victory last night.
Okay, so victory last night was the judge basically said, you could have these expert witnesses, SEC can have these expert witnesses, but what he really did was saying, off the checklist is the expert witness decision. The next decision could be summary judgment, correct? Which means she might rule from the bench, either in favor of Ripple or the SEC.
Absolutely, Charlie. The this was a Daubert motion. Ripple has 10 expert witnesses, and the SEC has 5. Both sides challenged their experts and saying they should be excluded. The victory we got was there was an expert the SEC was offering who was going to testify as to what XRP holders thought in their head when they purchased XRP. Of course, he never interviewed one single XRP holder in his entire career.
This guy has ESP, huh?
And he received a $3 million contract from guess who? The SEC.
Oh, nice.
To serve as a witness. And so the judge excluded that part of his testimony that he's not going to be allowed. To your point, though, some people believed that the decision on Daubert motions on expert witnesses could come down simultaneously with the summary judgment motion. So I tweeted out yesterday that I wouldn't be surprised if we get a decision in a day now or within a couple
And
of
let's
weeks.
be real clear here. If the SEC wins, says, and they hold Ripple liable for selling XRP, which was an unregistered security, big thing, that means just about every crypto, except for maybe Bitcoin, and maybe even Bitcoin, could be considered a security. Correct?
Well, I mean, Gensler's come out and said that Bitcoin is the only one he's comfortable saying is a commodity. Right. So I think you can take Bitcoin off the table for that.
Let's just say the SEC wins this, and a lot of people think they will, given what happened with Sam Bankman-Fried. That it's going to be hard for a judge to basically side on the in crypto's favor. Does it have a ripple effect through the industry in the sense that how does that make Coinbase? That means Coinbase. That means Binance. All brokered unregistered securities. Aren't they kind of on the hook?
Well, it's going to be a huge precedential value if the SEC wins, because when you look at XRP, it was created in 2012. It was the third largest cryptocurrency in the world when the SEC sued Ripple. It was traded, Cheryl, for 7.5 years in the United States and around the world openly and fairly without any interaction from the SEC. And then the SEC comes in 7.5 years later, after it was declared convertible virtual currency by the FinCEN, right, and declared by FSOC as virtual currency, by the Government Accountability Office as a virtual currency utilized in a decentralized platform. After all of that, the SEC comes in after all those years.
Okay, they still have a strong hand. If they win, that ripples throughout the industry.
And that's what I was getting at. If XRP is deemed
do you
security,
think they're going to win?
No. I think the SEC is going to lose, but that doesn't mean Ripple's going to get an outright win either. But I think the SEC is going to lose at summary judgment because of the theory that they went with. Charlie, normally when you go after a promoter, you say, well, on this particular day, you made an unregistered securities offering or sell. And that particular transaction was a security, an investment contract. And now they're saying that all sales of XRP, the token itself is a security. And that's the problem.
John, this is why all eyes are on this case,
By the way,
and why Twitter blows up every time you come on the show. Just to point out, guys.
Yes, I think the SEC is going to win. And I'll tell you, it's going to be a bad day for crypto if they win.
Okay,
right.
we're going to get that dinner on that? Steak, you got it.
Can I come? John Deaton, good to see you again.
Thank you so much.
Please keep us posted on this. It's really been fascinating to listen to you talk about this case. All right, well, closing bell.
Well, there you have it. You know, the stakes have been made, right? You know, but John Deaton does offer some more in-depth and meaningful information that goes beyond the conversation that happened on Fox. Right after he appeared on Fox, he came on live on Crypto Law TV, and I had the pleasure to watch it, and shout out to John. I want to play this clip for you now so you can hear what he says to expand on that. This will be a long fight. And listen, you know, he's going to talk about, you know, the SEC going after other projects like Bitcoin. Now, we covered this yesterday. I believe we could see each technology sued, like proof of work, proof of stake. Ethereum could be next. We see consensus already being challenged by SEC versus Ripple against XRP. All of these different technologies, I think, get sued against the Howey for legal clarity. We hope that Gary Gensler's SEC does not win these, but it would put each one in a particular bucket. And then from there, I think you could get the framework for cryptocurrencies. The scary part is if the SEC wins during this process that seems to be taking place. So take a listen to what John Deaton says here.
remind everyone, you don't get the fair notice defense unless XRP or was deemed a security, not deemed, but Ripple sold XRP as a security. And so if the judge says Ripple sold XRP as a security, then Ripple's fair notice defense kicks in and says, yeah, but we didn't get fair notice. And so Ripple's already went on record to say that that is a jury issue, right? And so the judge could agree. And so there could be not just the fair notice issue, but, common enterprise, non-investment use of XRP, were XRP holders relying primarily on the Ripple efforts of Ripple, or did the token itself allow them a financial benefit independent of Ripple, all of those things. And so if that happens, you may not get the result you want, because the judge would then simply say, here is a decision. These issues must be decided before a jury, can't be decided until a jury trial is held and factual issues are determined. Now, if that happens, then of course there could be a settlement, because the parties don't really want to spend weeks and weeks in a jury trial, which won't be for another 6 months. And then there could be an appeal and all of that kind of stuff. And so it could lead to a settlement, but it may not. I think what you have to start preparing your mind for is that even though we've been fighting for 2 years, it may not be the result you get. Now, maybe I'm wrong. I've went on record. I just bet Charlie that I believe the SEC is going to lose. But I said that doesn't mean Ripple gets an all-out victory. And so we just don't know how aggressive the judge is going to be. Does she believe she has enough evidence to say Ripple, from 2013 to 2017, whatever, these specific sales were offers of unregistered securities? Is she going to split the baby like that, but then say ongoing and future sales? Or is she going to say whether or not ODL is an investment contract is a question for a jury? I just don't know. But I've been one of those people that have been trying to plant that seed that this may not be over at summary judgment. And so you have to mentally prepare yourself for the fight. And now everyone else needs to prepare themselves for the fight, because I'm not exaggerating. I've been told that there could be 200 to 300 crypto companies, projects that have been under investigation by the SEC for the last 2 or 3 years, which means there could be a slew of more enforcement actions coming forward. A year ago, Gensler doubled the crypto personnel. We just saw Eleanor Terrett just tweeted out that, or someone tweeted out that the SEC is bolstering again their personnel to go after crypto. On the spaces that I was a part of this morning with Scott Melker and others, there was a general consensus that the war against crypto is just getting started. Now, to an XRP holder, that sounds crazy because it started a long time ago, but to the rest of the crypto world, they're just starting to wake up. And I know there's so many XRP holders that say, well, we're going to get clarity and that's it. And the rest of them are shit out of luck.
Listen here.
And maybe that happens and maybe it doesn't happen. And so what everyone needs to understand is that it's the SEC that's the enemy. I think I'm starting to even see a crack in Bitcoin maxis, starting to see, where they possibly shouldn't be cheering Gary Gensler on, just because he's going after it. Because, I guarantee we're going to see Bitcoin come under attack. It won't be on the same type of attack, but I guarantee you we see the energy consumption issue raised up by tenfold in the next few months.
And that's really what we're talking about here. He is warning all of us to be prepared that the SEC versus Ripple could go to a jury trial, at least in part. This is what I've been talking about for a while now. The idea that we need to be prepared for this case to go the distance. Jury trial, some kind of appeal from each side, and possibly on to the Supreme Court. But it doesn't mean that we won't understand what secondary market sales are for XRP holders, because it should mean that it is not a security. This is getting interesting. We are closer than any other project on the planet to finding out where we stand legally in this space. And watch out for the rest of crypto. And we should be coming together, no doubt about it. Tribalism out the window, stronger together as we move forward here. Ladies and gentlemen, that's going to do it for me. Not financial advice from me or anyone else. It's my digital perspectives. Connect to Congress. If you haven't done it yet, connect to Congress. Do not wait. We do make a difference. John Deaton, intervening with all of us behind him in support, have already done so. Let's continue to do it together. I'll catch all of you on the next one.